I'm Lazarus Lundy.
Good morning, Your Honor.
Good morning.
Ashley Lundy for the people. Your Honor, this time people would waive any conflict between this honorable court and the Office of the Public Defender. The people do not believe that conflict exists. We have the waiver for the avoidance of all doubt.
Good morning, Your Honor. Hannah Mackey, requesting permission to practice under Michigan Court Rule 8.120 under Deputy Chief Public Defender Lauren Brown.
This title?
Yes, sir.
No. Okay. Permission to practice is granted.
Thank you, Your Honor. Your Honor, at this time, we waive any potential conflict between this honorable court and our office. And if any conflict were to arise, we waive that conflict so that this honorable court can hear these matters.
Thank you. Court,
Thank you, Your
for its part, also does not believe a conflict exists either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Crystal Pratt.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Pratt. Ms. Pratt, will you please state your name for the record?
Crystal Pratt.
Thank you.
Your Honor, this is a waiver.
Pratt, you're waiving your right to preliminary examination.
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, sir.
You understand you will not have that hearing. Proceed to circuit court for further resolution.
Yes, sir.
People also waive the right. Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Thank you. Your Honor, we acknowledge receipt of the information, waive formal reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for
April 3rd at 1:30 p.m.
April 3rd, 2025, 1:30 slide.
Judge, I assume that's the date that court gave you. She is in custody until April 8th in Oakland. So the court knows, so a writ can be prepared.
Does the court get, I can't remember, do you get spoken out of custody date?
Why are they trying to? They don't like the date. So.
Not that we don't know.
No, it's Apple and Childers. Stop. First case. I've done one case so far. Go ahead. I know. I'll take a recess. I have May 1st also.
May 1st, if the court would allow.
Who's taking their date?
She's been accepted into the restorative justice program.
Fine,
So
fine.
Once she-
Not concerned. I assume you guys know what you're doing. May 1st, 2025, 1:30 before Judge Slip.
Thank you.
Bond will continue. Court does call the case. The People versus Jacob Jackson.
Morning, Your Honor. Robert Ianni, Special Assistant AG on behalf of the people.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender. On behalf of Mr. Jackson and hopefully with Mr. Jackson, can you unmute yourself and say your name for the court?
Yep, Jacob Jackson.
Your Honor, this is going to be another defense request for an adjournment. Mr. Jackson indicated he paid a $1,500 bond in Ohio. I do believe, I'm very hopeful this case is going to resolve, but one of the issues will be how much he can pay towards his outstanding balance. And I've tried calling multiple times the jail. I wasn't able to get an answer as to where that money is or what that case number is because I wasn't able to actually talk with a human. I just left voicemails. So I would ask for one more adjournment to try to get that answer of whether that bond can be applied to his outstanding balance. I'm not sure if it was bond paid for this case or for another case. Mr. Jackson indicates he believes it was for this case. But I do think that would impact the potential plea moving forward if he's able to get that money paid towards the balance.
All right. That objection, probable cause April 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Bond will continue. What you may want to do, Ms. Yagi, is it was paid in Ohio.
Yes.
So you may want to check depending on how well, hold on a second. How much did he pay?
He says he paid a bond here that was I have the exact amount. I think it was almost 9,000 here, but then he indicated that he paid a bond also in Ohio that was, I believe, 1,500. Is that right, Mr. Jackson?
1,200.
You said 12, was it 1,200?
Yeah, 12, yeah.
1,200. I apologize, Your Honor, 1,200.
All right, what you may want to do, I don't see it, but what you may want to do is you may want to check 15th District Court.
Okay.
That rather than it coming to the sheriff's department, it may have gone to 15th directly if that was the case.
Thank you.
All right.
Thank you, Your Honor.
All right. Thank you. Court calls the case People versus Jeremy Anderson.
That's who wanted to people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Anderson.
Your name, sir?
Jeremy John Anderson, sir.
Thank you.
And Your Honor, we're asking to continue to examine.
Discovery is complete.
Yes, Your Honor.
What's my date?
March 25th.
People have their witnesses available the 25th.
We'll try.
Okay, that's resolved.
Preliminary examination in person, March 25th, 2025, 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Thank you, Your Honor.
Your bond will continue. Court calls the case of the People versus Andres Flores Nava.
Good morning, Your Honor. Michael Vincent on behalf of Andres Flores Nava. He is approaching.
Good morning, Mr. Vincent. Your name, sir?
Andres Flores Nava.
Thank you. You're requesting an adjournment?
Yes, Your Honor. We just actually yesterday stepped into the case.
27th or the 3rd, which is here with you. 27th or the 3rd.
The 3rd, please.
Thank you. Probable cause conference in this matter without objection will be adjourned April 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond with its conditions will continue. Thank you. Court calls the case of the People versus Don Lee.
And is that on behalf of the people?
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Donnelly.
Your name?
Don Lee.
Thank you.
Your Honor, requesting a short adjournment to make sure I have all the discovery before moving forward.
March 27th,
Thank you, Your Honor.
2025, 9 a.m. Bond continue.
All right, thank you.
Thank you, Your Honor.
Thank you.
27.
Court does call the case of the People versus Mia Harris. Your name?
Tamaya Harris.
And what are we doing?
Asking to move forward to exam, Your Honor.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 25th. Preliminary examination will be set in person, March 25th, 2025, 9 a.m. before. That'd be me. Thank you. Thank you, though, Ann.
I'll circle the date on the calendar, Your Honor.
All right. Bond will continue. Thank you. Court calls the case of the People versus Stevie Brooks.
And is that on behalf of the people?
And good morning, Your Honor. But please, this honorable court, Brandon Bird, PA 3734, on behalf of Stevie Brooks, who stands to my right.
Name, sir?
Stevie Brooks.
All right. And you're requesting an adjournment?
Yes, Your Honor.
Oh, you were assigned on March 10th. All right.
And Your Honor, if I could address bond appropriate as well.
All right. Probable cause conference will be adjourned to March 27th, 2025, 9 a.m. or as your invite indicates. Yes, Esteban.
On 310, the defendant called his mother, and in this call, the defendant says, do you have the girl's new number? And she says, who's? He says, the girl. She says, nah, she got a new number. He says, she hasn't called you from the 262 number. And she says, probably so what's up? He says, you need to give her a call. I'll be doing 10 to 20 years. He says, they set up 10 years. That's what one of them said. He said, I'm just saying they're talking to her. He says you could say something to her. So I'm concerned he's having third parties reach out to the victim on this case through his jail calls.
Any response?
Yes, respectfully, Your Honor, I had a thorough discussion with my client yesterday, and especially about contact, having no contact with the complaining witness. And he understands that he has to have no contact with the complaining witness. He doesn't want to be in jail. Actually, we were going to ask for, to lower his bond to a personal bond so he could be released. He's 45 years old, lifelong resident, Your Honor, has a stable job in which he's risking losing everything if he's in jail. He doesn't mind wearing the tether or abiding by any other conditions. I understand this isn't a good look for him to abide by conditions due to the fact that he made that phone call, but that phone call wasn't threatening in nature. And he reached out because he was scared. He was forthcoming with me about that phone call, actually, when I had a discussion with him. So respectfully, Your Honor, I do understand that that was a violation of probably one of his bond conditions, no contact through a third party. But after discussing the matter with my client, he's gonna lose everything if he's here. He understands if he does anything of that nature, he's gonna be right back in jail. He's gonna be right back in jail if this court were to allow him to get out today. He has a litter of puppies that's not being taken care of, two dogs that need his attention. If he can't go back to the place of the location, Your Honor, he can live with his mother at an alternate location. So respectfully, Your Honor, I do understand we had this phone call in front of us and it may be damaging, but I told him about it. But respectfully, Your Honor, we're gonna ask this court no contact for a no contact condition. If this court wants to put a tether on my client, he has no problem with wearing the tether. He has no problem with going to an alternate location. That's what we're gonna be asking for.
Your Honor, I would object to any change in his bond. He has numerous dismissed CVs. I believe he also has a hold out of Lapeer for a violation of probation and a hold out of Dearborn for an OWI. In this case, in the report, there are 5 incidents of domestic violence, and one of those is a strangulation of the victim reported to officers. So I have extreme concerns, especially with him trying to reach out to third parties, that he would be able to abide by court orders.
The defense motion for a bond reduction is denied. Bond will continue. With reference to the phone privileges that the defendant has, it's clear that he violated those provisions. He can't. It's made clear to him no contact either directly or through third parties during the time of his arraignment. So at this time, the court will also revoke defendant's phone privileges entirely.
Thank you, Your Honor.
Court calls the case of the people versus Amy, is it Burberry?
Cheryl Foster Tucker on behalf of Amy Burberry.
All right, what are we doing?
Your Honor, we do have a resolution.
Oh,
Yeah.
well, I guess, yeah. The plea form indicates that defendant would be pleading guilty to an added count 2 of use of a controlled substance. A 1-year offense upon a successful plea to that charge. Count 1 would be dismissed. That's the court's full understanding of the agreement.
That is correct, Your Honor.
Has she signed an advice of rights?
She did, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. Is that correct?
Yes.
All right, that is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes.
Is that correct? You've signed the advice of rights form, correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will? And
Yes.
because you believe that you are indeed guilty?
Yes.
January 18, 2025, at the location of 272 Clark Street, City of Saline, Washtenaw County, State of Michigan. Were you in possession of methamphetamine?
Yes.
Did you know you were in possession?
That's
Yes.
yes.
Had you used it?
Not that day.
So you had used it when?
Like a day earlier.
Pardon?
A day earlier.
Okay, the day before, so on the 17th?
Yes.
All right. And you knew what you were using at that time was methamphetamine?
Yes.
Yes? I need a verbal
Yes.
response. Counsel, has the court complied with the court rule and would it be proper to accept this defendant's plea?
Satisfied, Your Honor.
We'll accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be April 15, 2025, 9 a.m. 1483 District Court before Judge Freshour. Bond with its conditions will continue. Thank you.
Your Honor.
Thank you.
Court calls case People versus Jared Brown Hughes.
Alexander on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brown Hughes. So here, please state your name for the record.
All right.
Your Honor, we're asking for an adjournment. There's quite a bit of discovery I need to review with my client. Can you sign the date here?
Without objection, March 27, 2025, 9 a.m. Bond will continue.
Thank you.
Court does call the cases of the People versus Joseph Hamby.
Peter Curry on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Hamby, who's approaching now on case 1672.
Sherilyn Foster Tucker, appearing on behalf of Joseph Hamby in the case ending in 9.
Your name?
Joseph Hamby.
Go ahead.
Your Honor, we're requesting a brief adjournment. We still are waiting on the correct videos for this case.
And we're adjourning to track with that as well, and then we'd be setting for an exam.
Probable cause conference, March 27th, 2025, without objection, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Davion Copeland.
Peter Curry appearing on behalf of the people.
And Assistant Public Defender Hannah Apple appearing on behalf of Mr. Copeland, who's approaching now. Mr. Copeland, will you state your name for the record once you're up?
All right, what are we doing?
Your Honor, we're asking that this matter be set for a preliminary exam.
All discoveries completed.
To our knowledge, yes.
People have their witnesses available the 25th. Preliminary examination in person, March 25th, 2025, 9 a.m. That is before Judge Moore. Bond will continue. Thank you.
It's okay. I'll put that.
Court calls case of the people versus Jessica Atterbury.
Good morning, Your Honor. Great to see you. Christina Costantino on behalf of Miss Atterbury. Judge, I was just assigned this case late yesterday. I unfortunately wasn't provided with a phone number for Miss Atterbury, so I've had no contact with her. And given the timing constraints, I doubt a letter would make it to her in time. So I would be asking for an adjournment of this matter.
And Your Honor, it's my understanding she has an active community corrections warrant with no bond.
She does. So we'll leave the no bond warrant out. On this matter. All right. Thank you.
Thank you, Judge.
Court does call the cases of the people versus Elroy Love, 3 cases.
And then on behalf of the people,
Christina Costantino on behalf of Mr. Love, who is approaching. Mr. Love, can you stand next to me and state your name for the record?
Elroy Love.
Thank you.
Judge, just a date and time set for PCC with regards to case numbers ending in 1460 and 1442. Discovery is complete. With regards to the case number ending in 1557, there is a body worn camera video that I do not have in my possession. I did speak with the people. They do anticipate that I will have that essentially any day now. I understand that if that video is not produced by the date of an exam, that it would not be the basis for any sort of adjournment. But my client has asked if we could set these matters for preliminary examination.
People have their witnesses available the 25th.
we'll do our best, Your Honor.
Preliminary examination in these matters will be set March 25th, 2025, 9 a.m. That's before me. All before me.
Wonderful, Judge. We look forward to seeing you then.
Yeah. Oh, joy. All right.
Thank you, Judge.
Thank you. Court does call the case of the people versus Amanda Abshire.
Dr. Lonnie, the people.
Your Honor, Kevin Dadush on behalf of Ms. Absher.
Sure.
She's on Zoom. Ma'am, can you state your name, please?
Amanda Absher.
All right. She's going to do, I have a plea form. Is that what we're doing?
That's correct, Your Honor.
All right. My understanding is that she's going to plead guilty to an added or no contest to an added count 2, attempting, resisting, and obstructing the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's further agreement of no delayed or deferred sentencing. Is
That's correct, Your Honor. That offer has been made in consultation with the victim in the case, and he is a
that a correct statement?
Yes, Your Honor.
All right, very good. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name again for the record.
Amanda Absher.
All right. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
2 things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
Say that again, please. You're going to have to speak up.
Yes, Your Honor.
All right. Basis for the no contest plea?
Lack of memory.
All right. And so, ma'am, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
I understand.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes.
Which one?
Probation.
Okay, were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 257787. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
People are satisfied.
Defense is so satisfied.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
April 15th at 10 a.m. with Judge Barr.
April 15, 2025, 10 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
I'll talk to you, Ms. Absher.
Court does call the case, People versus Jeffrey Williams.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Williams this morning. Please state your name for the record for me.
Jeffrey,
Thank you. Your Honor, discovery is complete, and at this time, we'd like to schedule this matter for a preliminary examination.
Would people have their witnesses available on the 25th? Preliminary examination in person, March 25th, 2025, 9 a.m. before Judge Moore.
Thank you so much, Your Honor.
Thank you. Bond continued.
See you next week. That's it for today.
That's it for you?
That's it for today.
All right. Have a great day. Court calls the case People versus, is it Tadreese Bentley?
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Bentley, Your Honor. Mr. Bentley's making his way to the podium. State your name.
Tadreese Bentley.
All right, thank you.
Your Honor, I have had a chance to discuss this matter with the prosecutor and with Mr. Bentley. Mr. Bentley, I have gone over his absolute right to a preliminary examination with him. He wishes to waive that examination.
Is that correct, Mr. Bentley?
Yes, sir.
All right, and you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Sir.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Gaddy.
Your Honor, as part of the waiver, there was an alleged pill. The people will not charge that.
That is correct.
That pill is part of this. Your Honor, we'd waive reading and stand mute.
Defendant ever waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
May 1st at 1:30 p.m. with Judge Slay.
May 1st, 2025, 1:30. Judge Slay.
Your Honor, if I could be heard on a bond condition.
Sure.
Your Honor, Mr. Bentley is currently testing. He is tested negative on every occasion. We'd ask the court to either discontinue testing, or he has renewed his medical marijuana card. We'd ask the court to allow him in the alternative to use as prescribed. He does have the card with him if the court needs to see it.
Is that the only thing he's testing for at this point? I don't have a report.
Oh,
That's it.
they're having him do a urine screen. I don't know what I assume it's just the standard panel, Judge.
Were there any narcotics or anything involved in it?
Yeah, I'm not going to gild the lily. The report said they found one, what they thought was ecstasy tablet. There's been no labs on it, and the people have agreed not to charge it.
I'm going to deny the request.
Would the court consider the medical use of marijuana?
Not at this time, unless I get some report.
All right, thank you, Judge. We'll track that down and submit it. Thank you. Or to Judge.
You'll probably have to submit it to Judge. Court calls case People versus Calvin Fuqua.
Asli Bashir, you're with and on behalf of Mr. Calvin Fuqua. Mr. Fuqua, you can say your name.
Calvin Fuqua.
We would like to set for preliminary exam in this matter.
All discoveries complete.
To our knowledge.
People have their witnesses available the 25th. Preliminary examination in person, March 25th, 2025, 9 a.m. That is before me. Bond will continue. Thank you.
Oh, okay, sorry. Could we address bond in this matter? I apologize.
Briefly.
Thank you. Mr. Fuqua has an elderly mother who lives in the address that he has as his mailing address with the court, who needs constant care, and he would like to return home to assist with her care. He is willing to go on tether and to do, to follow any conditions the court believes might be appropriate to show that he is not a flight risk. Mr. Fuqua also has some health conditions that he would like to be able to address out of custody while he's addressing this case.
Response from the people.
The people would object to any modification to the bonds. The fact that are alleged here is that this individual was intoxicated. He was being investigated for public intoxication and was found with a loaded 380 Ruger handgun in his left front pocket. There was also suspected crack cocaine found, although that has not been sent to the lab. At this point, people are concerned for the safety of the public.
Anything else?
I would just like the court to consider that this is, offense from several years ago, and I do believe that Mr. Fuqua, his behavior may have changed in the interim, at least.
Motion for bond reduction is denied. Bond will. Thank you. Court does call the case People versus Beverly Boss.
Testimony for the people.
Public Defender Natalie Pate with and on behalf of Ms. Boss, who is approaching. State your name for the record, ma'am.
Beverly Boss.
Thank you, Your Honor. I'm respectfully requesting an adjournment for continued plea negotiations and also to have another discussion with my client. We were unable to have a discussion since last court date.
March 27th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor. Thank you.
Court calls case People versus Julian Ward.
Andrew Troop is appearing on behalf of the people.
Christina Costantino appearing on behalf of Mr. Word. Oh, careful. All right, Mr. Word, can you please state your name for the record?
Julian Word.
Thank you.
Judge, this is a date and time set for PCC. I was just assigned this case late yesterday. We would be asking for an adjournment of the PCC.
Have a green sheet? No.
I do. Oh, shoot. You know what? I'm sorry. That would help if I gave it to you, not in my file.
Probable cause conference will be adjourned March 27th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
Thank you. Court calls case of the People versus Clarence Broach.
People, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Broach, you should be present via Zoom. Sir, can you please unmute and state your name for the record? Mr. Broach, can you hear us?
I can't hear you.
State your name for the record.
Clarence Broach.
Thank you, Your Honor. As to the case ending in 1038, I'm respectfully requesting to set that matter for preliminary examination. And then as to the case ending in 1039, I'm asking for a 3-week adjournment.
Why 3 weeks?
So that Mr. Broach can continue attendance in AA classes and get some documentation of that in order to provide to the people in hopes of plea negotiations.
All right, in case 1039, probable cause conference will be adjourned to April 3rd, 2025, 9 a.m. Bond continued on that case. Is all discovery complete on the other matter?
To my knowledge, yes, Your Honor.
People have their witnesses available the 25th.
We'll do our best, Your Honor.
Preliminary examination in that matter will be set for March 25th, 2025, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor. Thank you,
Thank you,
Mr.
Your
Broach.
Honor.
You're all set for today.
Thank you. Thank you.
Court calls case People versus Alua Gillis.
Yagi, Assistant Public Defender, excuse me, with on behalf, excuse me, Your Honor, of Ms. Gillis, who's, oh, I'm sorry, who's now standing to my right.
All right, you're requesting an adjournment.
I am, Your Honor. I'm requesting a brief adjournment. Ms. Gillis has court in her other case next week, and I think it would be very beneficial to continue conversation with her as well as see what's going on with her other cases.
Without objection, probable cause conference adjourned March 27th, 2025, 9 a.m. Bondwood.
Thank you.
Court calls case of the People versus Byron Brown.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Brown, who's here.
Brown, unmute and state your name.
Zyron Brown.
All right, what are we doing?
Your Honor, I've had a chance to talk with Ms. Lundy and with Mr. Brown. At this time, Mr. Brown is going to waive his right to a preliminary examination. I have gone over that right with him, and he wishes to waive. It's my understanding the people will not. He was 20 at the time, but the people will not dispute his request for height if he does up there.
That's correct. There's no way the circuit court to seek HIDA there on the charge count of uttering and publishing.
All right. Is that correct, Mr. Brown? You're waiving your right to a preliminary examination?
Yes, sir.
And you understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Gad.
Your Honor, we waive, waive reading, stand mute, and acknowledge receipt of the information.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
May 5th at 1:30 p.m. with Judge.
May 5th, 2025, 1:30, Judge Hamud.
Thank you, Your Honor. Would ask a bond continue.
Bond will continue. Court calls the case. People versus Micah Jones.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Jones, who is approaching. Please state your name for the record, sir.
Micah Jones.
Thank you, Your Honor. We wish to set this case for preliminary examination. All discovery is now complete.
People have their witnesses available the 25th. Preliminary examination in person, March 25th, 2025, 9 a.m. That is before me. Bond will continue.
Thank you, Your Honor.
Court calls case of the people versus Mark Capaldi.
Ashley Lundy for the people.
Assistant Public Defender Asif Bashir here on behalf of Mr. Mark Capaldi. I have Mr. Capaldi was his custody status recently changed, I believe, 2 days ago, and I have not been able to be in contact with him. I have not.
Should I let you go on or should I read my note?
Thank you.
What do you want me to do? I mean, I'll let you talk.
Oh, sorry.
He said he's going to be late. He had to jump his vehicle. However, he does say unknown ETA.
Thank you, Your Honor.
The information I have is that I believe he told Community Corrections that both of his cars were stolen. Both?
Both of his cars?
Both.
When?
That's a great question, Your Honor. I don't know.
When did he tell Community Corrections?
I talked with Mr. Joshua Bennett today, and there were some questions about the tether zone and how big it was because the victim is the next door neighbor. I indicated that home confinement might have to work, and Mr. Joshua let me know he may not come today. He claims both of his cars were stolen, and Community Corrections told him to talk to his attorney. So I'm gonna ask him.
I'm just trying to figure out. But he's jumping his vehicle.
Right.
So does he have 3 cars?
That's a really good question.
I don't know.
But I know where he's not, which is here. So I'm asking for a warrant.
What? He borrowed a car with a dead battery. Oh, that's all he could get?
Your Honor,
What would you like me to do, Mr. Chair? Since we have conflicting messages.
I will, in light of the, Mr. Capaldi has, contacted the court ahead of time. I would request that we pass this matter and address it, and I can try to look for him.
Are we really just postponing the inevitable?
Alternatively, I would request an adjournment in this matter.
Yeah, okay. Nice try. You know what? We did this last week with you, didn't we? And the week before. Something with your client.
I will note that.
No, let's see if he has a car.
Okay.
So I'll pass it.
Thank you, Your Honor.
I can't wait. Do you think? No. Maybe he got one back that was stolen. No? Okay. Trying to help out. Court calls the case, People versus William Jones.
Good morning, Your Honor. First Assistant Public Defender Anderson with and on behalf of Mr. Jones, who's approaching. Go ahead and say your name, Mr. Jones.
William Jones.
Thank you, sir.
Happy 313 Day, Judge.
Oh, cool. I didn't know. I thought she was doing a Detroit thing.
It is.
Your Honor,
It's nice to have you back, Miss.
thank you, Judge. Your Honor, we've had a chance to talk to the prosecutor as well as my client. We're gonna ask for an adjournment for referral to an investigator.
Do I have a green sheet?
I submitted it via email a couple days ago.
You email a green sheet, doesn't that make it?
So we need.
Yeah, that's what I'm thinking.
With our plan.
That's okay. You recall
I'll let her know what we're doing, so she understands.
because it's in somebody's file, okay? Bravo Cross Conference, March 27, 2025, 9 a.m. Bond will continue. Thank you.
Here you go, Mr.
Court calls case, People versus Antonio Carr.
Andrew Childers appearing on behalf of the people.
On behalf of Antonio.
Antonio Carr.
Today is the date and time set for PCCs, Your Honor. We're gonna set this for a preliminary exam.
All discovery is complete. Yes.
Yes.
People have their witnesses available the 25th.
That's fine, Your Honor.
Preliminary examination in person will be set March 25th, 2025, 9 a.m. before Judge Moore. Bond will continue. Thank you. Court does call the case, People versus Angeline King.
Alexander, on behalf of the people, Your Honor.
Mr. King, could you please state your name for the record?
Wow. Thank you. You were actually in the courtroom.
Yes, sir. I did that for you
No,
today.
I'm shocked. I'm shocked. I thought we were gonna wait, but we're not. Go ahead. Yes, you may.
And sign this right here. Your mom, because your mom wants to talk to me about your case. And I
Now or just wait for
Pardon?
3 weeks.
Paying it to the court. How's that happening?
If we want to set it up to have him pay it for the court, pay it to the court directly, that's fine. If Ms. Mackey wants to prepare an order for that.
I can prepare an order for that, Your Honor.
Really?
Yes.
If you're asking for the adjournment, why don't we have it now? Never mind.
It'll all be done in 3 weeks.
No, I'm not. I'm just asking questions. And so would you be able to get the total amount paid by the 3rd? Is that the deal?
Absolutely, sir. Yes.
Okay. So what I'll do is I'll adjourn probable cause April 3rd, 2025, 9 a.m. He will have to, he has to pay that.
That is correct.
Okay, so he'll have to pay that 15th District Court. Okay, in this case, all right. So once the order's prepared, I'll sign it and then he can pay it there.
Awesome.
Okay.
Honor.
All right.
Thank you, Your Honor. You'll have that order soon.
Yes, April 3rd. Have Brown prepared. He's not doing anything. Court calls case People versus Tyler Pittman.
Andrew Chilby's appearing on behalf of people.
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Pittman.
They're gonna have to move about it.
Oh, I'm sorry. I did that.
Yes, twice now.
Go
Go ahead.
as well. I met with Mr. Pittman yesterday. He indicated that he had signed paperwork to retain an attorney, Mr. Killawald. And so I was kind of thinking Mr. Killawald would be with him. You haven't heard from him? Okay. I would ask for a brief adjournment. Mr. Killawald is representing him in his other case.
Got it.
And this is a situation where unfortunately he's held on the other case, not this case. And so
Got
not
it.
sure.
March 27, 2025, 9 a.m. bond continued.
Thank you, Your Honor. Okay, can I call you?
Court calls case People versus Shauna Colston.
That's a lot of people.
Good morning. Assistant Public Defender Lauren Perny on behalf of Ms. Colston.
Good morning, Ms. Parody. How are
Good
you?
morning, Judge. I'm well. How are you?
Doing great.
Good.
But you don't have a client, so you're probably not doing well.
No, I do. I see her.
You? Oh, yay. Okay.
Little faith, Judge, and Ms.
No,
Colston.
I had faith in you.
Oh, good. Good. Ms. Colston, please state your name. I think you're muted.
She does. Can you state your name, ma'am? Okay, good job, Parody.
Well, she's here, Judge. I hope that if Ms. Colston, can you wave your hand if you can hear us? Okay. Well, we're asking for an adjournment. I think we're very close to a resolution. The people just need to verify with their witness.
Probable cause conference, April 3rd, 2025, 9 a.m. Bond continued.
Thank you. I'll shoot you a text, Ms. Colson, just to make sure you have the date, okay?
Thank you, ma'am. Court calls case People versus Viraj Scott.
Andrew Childers appearing on behalf of the people.
Sorry, Your Honor, Mike Getty, Assistant Public Defender on behalf of Mr. Scott. Your Honor, yesterday we submitted some competency orders, been referred in the matters that are already pending in circuit court as well.
Or no, 60, it should be, but. All right, forensic evaluation is ordered. I've signed the orders.
Thank you.
Set a competency hearing for May 15th, 2025, 9 a.m.
Thank you, Your Honor. Your Honor, if I could be heard on bond.
Yes, briefly.
Your Honor, Scott is here. As the court's well aware, he's a longtime resident of Ypsilanti. He's not a flight risk in any way. This matter is charged out of a store over in Ypsi as well. If the court he is being held in the circuit court cases on $25,000 each. If those, we'd ask for a personal bond in the event he's able to bond out in those matters with house arrest, tether, and a no-go to the alleged location of the alleged offense. We'd also ask that he would also certainly drug testing and any other screening as appropriate in terms of community corrections, outpatient treatment program.
So here's the thing, so that you know, yesterday, I think, was it his mother or grandmother? They were trying to hand some documents to me yesterday. I told them I couldn't accept them in that fashion. And so I told them that they may want to contact you, Mr. Gay. My further understanding is I believe that Mr. Scott, I was informed, and I'm not sure of this, has a guardian.
My grandma.
Hold on. And so I'm not sure how that would play into any contemplation of a release on this. So at this point, what I'm going to do, and I don't need a response from people, is I'm going to deny the request. Something has to be put together for me. I'll hear the motion, but I'd have to see a much clearer picture of exactly what's going on with this.
Thank you, Judge. And if we, it's kind of, there's two courts, and so if we can get clear on the other one.
Who's the other?
I think it's Judge Slay, Judge.
Judge Slay.
And Judge Barr. He's actually got a 10,000 with Judge Barr as well.
With the paraphernalia thing, I don't know.
What?
Paraphernalia or something?
Where?
For the $10,000 bond.
There's a paraphernalia.
Yeah.
Okay, that's before Judge Barr, so you'll have to deal with that.
Okay.
Okay. All
Thank
right.
you, Judge. And my apologies, I didn't catch the competency hearing date.
May 15th.
Thank you, Judge.
All right. Court calls the case People versus London Daughtery.
Andrew Childers.
And I'm Maggie on behalf of Mr. Daughter.
Mr. Getty. That's his grandma. I don't know if you know. That's who had the documents. Yeah, she's here.
Please state your name for the record.
London Daughtery. Thank you.
Your Honor, at this time, we are adjourning the matter for 1 week, please. I have it.
Like which green sheet? More to come. They're doing a mitigation report.
Yes, Your Honor. Oh, 3-week adjournment.
3? You said 4 here.
4-week adjournment.
Please,
Your Honor.
What? Why are you piping in? She was doing just fine. Probable cause conference, April 10th, 2025, 9 a.m. Bond.
Thank you, Your Honor.
We'll continue. Thank you, sir. All right. Court does call the case of the people versus Ronald Sims.
Assistant Public Defender Jay Bellinger on behalf of Mr. Sims, who approaches.
Good morning, Mr. Bell.
Mr. Sims, good morning, Your Honor. Can you state your name for the record?
Yeah, Ronald Sims.
Thank you. He's waiving.
He is no opera at this time, Your Honor, so he will be waiving.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Bear.
Your Honor, we acknowledge receive the information. Waive formal reading, stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
March 25th at 1:30 p.m. with Judge Combs.
March 25th, 2025, 1:30, Judge Combs.
Thank you. And I'll have Gina in touch with you. Okay.
Okay.
All right. Thank you.
Continued. Thank you. Court calls the case people versus Shania Driver.
Hannah Mackey on behalf of Mrs. Driver. My right. Please state your name for the record.
What are we doing?
Your Honor, we would please like to request that we adjourn this matter. 2 weeks, please.
Checking. That might have done that Kalina Anderson thing. Probable cause conference, March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Charles Williams.
Ready, Judge?
Oh, you're gonna do something today. All right.
If you allow me to, yes.
Go for it.
Thank you, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Charles Devon Williams.
Thank you.
We have two requests today, Your Honor. We're requesting that this matter be set for preliminary examination.
Discovery is complete.
That's my understanding. Yes, Judge.
People have their witnesses available the 25th. Preliminary examination in person, March 25th, 2025, 9 a.m. before me.
Thank you, Judge. Our second request, if I might, is for a adjustment to the bond to allow for Mr. Williams to potentially go to inpatient substance abuse treatment. As you can see from the charge, this is a situation where he allegedly had narcotics, and I believe Mr. Williams wants to get ahead of that, if possible, and go to an in-jail or inpatient treatment facility of some type if the jail is able to find something for him.
Any response from the people? I will indicate that defendant may be released to inpatient treatment on a PR bond.
Thank you.
It would be better, counsel, if you prepare an order to that effect. I'll sign off.
Thank you, Judge.
All right, thank you.
He said yes, we'll find you a place.
Okay. At this point, his bond will continue. Court does call the case of the people versus Debbie and Julia Martinez.
Ready, Judge, or ready-ish?
She's in Zoom.
Oh, okay. Torshell Feaster, Assistant Public Defender, covering for Ms. Cannon on behalf of Ms. Martinez.
Ms. Martinez, can you get yourself unmuted and state your name?
Okay.
Go ahead, state your name.
Devin Julia Martinez.
Thank you, Judge. Speaking of Ms. Cannon on this matter, my understanding is she was intending to do a waiver of this to circuit court. Ms. Cannon has signed the document, but she was thinking Ms. Martinez would be in person and she could sign it that way.
All right. Ms. Martinez, is your understanding that you're waiving your right to a preliminary examination?
Yep.
Okay. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed or the offenses alleged were committed and that you committed them. You understand that?
Yeah. Well, actually, I want to plead no contest.
We're not pleading
Okay.
yet.
Hold on.
Okay, yeah,
You may be pleading no contest in circuit court. Is that you think?
yeah, believe so.
Okay, so you understand that you're waiving your right to a preliminary examination and you're headed to circuit court. You understand that?
Correct,
Okay, and that means you're not gonna have that hearing in here,
Correct.
down here.
Right.
Got it?
Right.
Okay. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Judge. We waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
March 31st, 1:30 with Judge.
March 31st, 2025, 1:30 before Judge Hamud.
Thank you very much, Judge.
Thank you. Bond will continue.
We were hoping.
Thank you, Ms. Martinez.
was hoping
Pardon?
to lower the bond, possibly. I did
I
ask
don't
for that.
have notes to that effect, but Your Honor, based on my client's request to discuss bond, I'd ask the court to consider a reduction. It just sounds like she is intending to resolve this matter at circuit court with a no contest plea. So I ask the court to
Doesn't she,
consider.
I think you have other matters pending, don't you?
Just that that will be resolved in the final trial on the 20th. Yeah.
But you're being held on something else?
On the 20th, it will be resolved.
Okay, who's that before?
Valvo,
Pardon?
Judge, Valvo.
Judge Valvo?
Yeah. But she has another, so
She wanted to see
Ms.
how this
Martinez,
worked out.
when you say to be resolved, what do you think is gonna happen on the 20th?
Nothing, no charges will be pressed. I believe.
Judge,
Okay, let me ask you this. Are you in Judge Valvo's mental health court?
No,
Is that where, no? It's just a straight case before her?
yes.
I don't know anything about that.
either do I, Your Honor, what I might suggest is if that case is resolved on the 20th, Ms. Cannon can speak to the prosecutor with Judge Hamud and see about potentially doing a step in order to have her released if that works.
I would be going for the record
Marvelous.
Go ahead.
that, she does have a hold out of nobody, for possession of narcotic paraphernalia. And I think we did discuss there's an assault and battery out of 15th District Court. It
That's
looks
the
like
one
about-
point. Yeah, it's not true and it's gonna be dropped. So, yeah, I was hoping. What?
Okay, so here's what we'll do, Ms. Martinez. I'm gonna deny the request to change your bond at this point. I'll go with Mr. Feaster's suggestion, if your case resolves on the 20th, you can get your request before Judge Hamud regarding your release.
Thank you so much.
Okay. All right, thank you.
I saw you on the
Okay.
news, by the way. I saw you on the news.
You saw me on the news?
You looked awesome, yeah. Cheers,
Well,
man.
thank you. Thank you. I don't get that much, so I appreciate that.
I have some good
All
endeavors
right.
coming up with Dr. J too, so I'll see you later.
All right, take care, Mr. Martinez.
Thank you, Judge.
Thank you. Court does call the case, People versus Thomas Elkins.
People.
Assistant Public Defender, Chauncey Carey, I can really, on behalf of Mr. Thomas.
Oh, so both Feaster and I can really are gonna do something. What is that?
First Assistant Public Defender Colin Anderson with it on behalf of Mr.
Oh, hold it. Whose case was this? Who are you?
No, who are you?
What?
Colin Anderson. Talks about in the drug court, is that?
Ellis?
Are you Ellis or Elkins? What's your name, sir?
I wanted Elkins.
Okay. I have Elkins.
That's what I said, Elkins. Who's that?
Ellis.
Same first name, Your Honor.
Same first name. Sorry, Your Honor. For the confusion of your name. Just saying.
Shanaza? Shanaza?
Yes.
Did you want to apologize to the court or no? No, never mind. Mr. Elkins, can you state your name, please, now that we have the PD sorted out?
At least we were here and ready.
Which for one of you was a shock for me. All right. Mr. Elkins, can you state your name?
Thomas Elkins.
And I'm presuming you stopped smoking because you're in court.
Oh, yes, sir.
All right.
Your Honor, I'm asking for a 4-week adjournment for drug court referral. I submitted a copy of the referral as well as the green sheet.
Oh, you have a green sheet this time. That's neat. Okay. I don't, Anderson. I don't have
Supposed to go
refer-
well today.
Hold on.
This was all supposed to go well today, Judge.
I know. You indicated that, but so far it's not.
That was my
So
intent.
I will sign off on the referral
Okay.
once it gets to me.
Okay.
You were looking for a 4-week,
Yes, Your Honor. I talked to Mr. Reyes. He needs a little extra time.
April 10th, 2025, 9 a.m. Bond continue. You have the form? Quit confessing to what Polina hasn't done. Thank you, sir.
Thank you very much, Your Honor.
We'll be in touch, Mr. Elkins. Thank you.
Okay, thank you,
Court
ma'am.
does call the case. People versus James. Oh, I don't know. No. Is this black? Are they ready?
We're ready.
Are you two ready?
Yeah, Your Honor.
Oh.
I want to see it. I don't want to.
And here we go. Court calls the case. People versus James Balfour.
Good morning, Your Honor. Marie Tanhall, Assistant Prosecuting Attorney on behalf of the people.
And good morning again, Your Honor. Christina Costantino on behalf of Mr. Vacapor. Mr. Vacapor, can you please state your name for the record?
James Vacapor.
Thank you.
Judge, may we briefly approach on this matter?
There's a pattern. Yes, you.
Thank you.
All right, record should reflect you had a bench conference in this case. There is a request to this matter, which I will grant. I'm going to adjourn it to timing wise, I'm going to go to April 17th. Probable cause conference will be adjourned at that date. The court is expecting a communication regarding bond in this case. And the court will, once receive that, will take a critical look at it, and make its decision.
Very much, Judge.
Right, thank you.
Appreciate it.
Court calls the case, the people versus Thomas Ellis.
Absolutely, for the people.
That's Alice.
Thomas Ellis.
Alice. Alice.
Hannah Mackey on behalf of Mr. Ellis, who is appearing to my right. Please state your name for the record.
Hold on one moment. So why did you get up at all? Because you weren't on the other case and you're not on this one. Acting really?
Yes, Your Honor.
This is
Why
her
did
case,
you
Your
get up at
Honor.
all?
I initially was going to handle Mr. Ellis's case, but I asked Hannah if she could, get some more practice.
You just didn't want to get up because you knew I was going to have something to say. Georgia, all right, go ahead, sit down. All right, go ahead, yes.
Good morning, Your Honor. We request for a 2-week adjournment, please. Your Honor.
Your name, sir? Thomas Sullivan. See, and I knew that. Nobody else did. Yeah. I'll grant the request for an adjournment. Probable cause conference, March 27th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, sir. Thank you for your patience. Court does call the case, People versus Michael Horn.
Absolutely, for the people.
Good morning, man. Please, Honorable Court. Kareem Johnson on behalf of Mr. Horn.
Your name, sir?
Michael Horn.
All right, what are we doing?
Yeah, we're asking this matter be set for exam.
All discovery complete.
Yes, Sean.
People have their witnesses available the 25th?
I'm sorry, Your Honor.
Would people have their witnesses available the 25th?
We'll try, Your Honor.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before Judge Moore.
May I address bond?
You may.
Yeah, this case was reissued after a dismissal. Do not see any objective reason why the bond should be so high, $500,000. Believe there's any witness or concrete evidence that my client fired any shots, or is there any witness or concrete evidence that my client was the driver of a car in which shots were fired from? Understanding we're going to have a preliminary examination in this matter, but from all the hours of body camera footage that I was able to review, witness statements, and I know cases can be made by circumstantial evidence, Your Honor, but I don't even see it circumstantially here. And when looking at my client's youthfulness, I don't think he's a flight risk. He has family in the courtroom, his grandfather, his girlfriend, his child. I think the court can look at a lot less restrictive means, house arrest, tether, to ensure the safety of the community and that he will not flee, Your Honor. But do not think that my client is a flight risk. And without concrete evidence that he fired shots at anybody or drove a car knowing that shots were going to be fired at anybody, I don't see how he's a danger to the public, Your Honor.
When you say it was dismissed, I mean, it's a reauthorization?
Yes, Your Honor.
That's correct, Your Honor. When it was up for exam initially, the officer in charge was out of town. So the case was dismissed at defense request and we did refile it.
Got it. Okay. Response. Good luck.
Your Honor, I do think the bond is appropriately set. We did put in our bond information form that this was a case involving shooting and the potential for shooting at a building. I do think that the facts in the case will be borne out, hopefully, at the preliminary examination to give all of the factual basis for this case. This shooting on Andrea Street is believed to be in retaliation for a different shooting that was related to something else where this defendant was positively identified at that prior one on Knollwood. So we are asking that the court continue the bond and keep that earliest possible preliminary examination date of March 25th.
Yeah, may I respond?
Right.
So it seems to be that the people's theory is that because my client's mother's house was shot up and he was present when it was shot up, he must be responsible for this other shooting, although no witnesses put him at the scene of that shooting, Your Honor. And I don't think that
You're saying
at the second shooting. Yep. We will concede that there will be evidence that he was present at home when his mother's house was shot up. But that's it. There's no evidence that he left that location to go shoot up anybody else's house or drove anybody to go do that. And because of that, I don't think a $500,000 cash shooting bond is fair.
Anything else, Ms. Lunder?
No, Your Honor.
All right. Oh, okay. So the first shooting, when did that allegedly take place?
Approximately an hour to hour and a half earlier that night. And
we're not talking days.
It's very close in time, is my understanding, Your Honor.
Okay.
The car involved in the shooting was stopped. The second shooting.
Okay.
Was stopped that night by law enforcement. My client wasn't in the car.
He was not?
No, he was not.
Okay.
But it was the car was registered to him, Your Honor. That is will be a fact that we will be conceding at exam and trial.
Okay. So I'm not jumping to any. The car that was involved in the second shooting belonged to the defendant.
Yes, sir.
That approximately an hour before, correct me, but sometime just shortly before that, the defendant's mother's home was shot up.
Yes, sir.
Yes.
And Counsel, you said he was present at the home when his mother's house was shot.
He arrived after the house was shot up.
Got it.
He's on body camera, but he's not on body camera leaving in the car that is caught after the second shooting, the shooting we're here for. He's not in the car.
Okay. All right, I got you. I think. All right. Well, what I'm going to do at this time is I'm going to deny the request for the bond reduction. I'm going to leave bond set where it is. We're 10 days out or whatever it is from a preliminary examination. Let all those facts come out, and then let Judge Moore make a decision as to proper.
Yes, Sean.
Thank you.
Thank you.
Court does call the case People versus Justin Fuller.
And send on behalf of the people, Your Honor.
And Mackie on behalf of Mr. Fowler, who is approaching. Please state your name for the record.
Justin Foley.
Yeah, he's gonna.
Huh.
There you go. All right, go ahead.
Your Honor, at this time, we request that this honorable court adjourn this matter for 2 weeks pending media discovery.
Probable cause conference will be adjourned at March 27th, 2025, 9 a.m. Bond will continue.
Your Honor, may I address bond real quick?
Doubt.
A bond condition.
No, oh, condition. Okay, no,
Sorry.
go ahead. I didn't know where you were going, but go ahead.
Your Honor, as we know, the purpose of bond is to ensure the safety of the community and that our client appears to court, which he has. He has no history or violations of any drug or alcohol use, and in this specific case, no alleged use of alcohol or drugs. We ask that this court remove his testing requirement so that he can work, and it's been hindering with his work to come in randomly to test, and it costs money. Or we ask in the alternative if we could.
He's on a standard domestic violence condition, and that's where his testing is coming out of.
Yes, Your Honor.
Okay, go ahead.
I spoke with APA Zenda on this matter, and
How was that?
Pardon?
How'd that go?
Oh, she was leaving it up to your discretion, Your Honor.
What?
Yes.
Oh, you have a position? I'll wait to hear from her. Go ahead, I'm sorry.
So we do ask that that condition be removed or at least set on a specific time or day so he can arrange his work around that. And I have a paper here, Your Honor, that shows where he works and the time and everything.
I don't know what I'm supposed to do with that, but fine, I'll take it.
Oh, well, maybe approach actually with it. Please, Your Honor.
You know, if you wanted to approach, you should have led with that. You sit down. You leave her alone. She's fine. Come on. Court recalls the case of, sure we're all on here, People versus Fuller.
And send on behalf of the people.
Hannah Mackey on behalf of Mr. Fuller.
All right. Record should reflect before the system went down, but there was a bench conference in this case. I had to adjourn this matter out in case we didn't get it to March 27th, 2025 at 9 a.m. Counsel, was there anything else you want to put on the record?
None, Your Honor.
All right. All right. Court does recall the case, People versus King.
Alexander on behalf of the people.
Stephanie Cannon on behalf of Mr. King. Your Honor, it's
Oh, I'm sorry. Did you say your name? Okay. As far as his case ending in 0279, we're asking for a 1-week adjournment. I did get discovery. I got it today. I just need to go over the discovery, listen to the cause, and see what's happening with there. So we're going to request a 1-week adjournment as it relates to that.
All right. Probable cause conference will be March 20th, 2025, 9 a.m. All right. As to the issue regarding bond.
Your Honor, I do want to address bond, but I spoke to my client about his bond current situation right now because of his case before Judge Hammoud, the pretrial. It's my understanding there's no bond there. He gets to see her on Monday. I'm going to try to address bond with her, and then when we come back, I'm hoping we'll be able to, as far as my request for bond goes. So once I address her case, I'm sorry, the case before Judge Hammoud, which I think is set for this Monday, I'll have a hopefully the change in circumstances necessary to make a request before this honorable court.
And Your Honor, I would just ask if the defendant were to be released, when we do address it, if one of the conditions for the no-go to be that he cannot go to the campus of Eastern Michigan University.
Your Honor, I'm not sure if his mom is still present, but she was here earlier, and her intent is to take her son home. And she lives in Detroit, and he'll be in Detroit with her.
Okay, so if I added the condition to not enter Eastern Michigan University campus,
it won't be a problem.
Be an objection.
None whatsoever, Your Honor. He's moving to Detroit with his mother.
Then I will have the bond continue. I will add the condition defendant to not enter EMU campus. All right.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Need an order. Court does call the case. People versus Eric Fowler.
Ashley Lonnie for the people.
And I'm acting on behalf of Mr. Fowler. who is At this time, sick, Your Honor.
What?
He's fallen ill. So we ask for a 2-week adjournment, please.
And he was here last time. I was opposed to the request.
Wow. I'm like stunned. I'll have no words. Probable cause conference, March 27, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Across the case of the people versus Durantu Francis.
Ashley Lonnie for the people.
Assistant Public Defender Chinazi Carey, I can do on behalf of Durantu. Your Honor, can we approach on this matter, please?
Yeah, you might want to.
Yes, Your Honor, we.
All right.
I'm good. Okay, we're back on the record in the Francis matter. What I'm going to do is I'm going to adjourn this out, the probable cause conference out to the 20th, 1 week out. 2025 at 9. Defendant is to report to community corrections before you leave the service center, and you're to be placed on a GPS home confinement tether.
Thank you very much, Your
Your
Honor.
Honor, there will be a tether with no exceptions.
No exceptions. It's home confinement.
Thank you, Your Honor. She said, wait, hold on. Thank you, Your Honor.
Let's call the case people versus Taiwan Griggs.
They told me to get in touch now.
They told me, Luke.
Taiwan Griggs, I need a prosecutor.
Stephanie Cannon on behalf of Mr. Griggs, who is appearing by Zoom. Mr. Griggs, could you please state your name for the record?
Taiwan Griggs.
Thank you, Your Honor. In this case, there should be a request for an adjournment. He is working with our AIM team. However, because of where he was Lighthouse, our AIM team couldn't get in touch with him. Since then, I got them in touch and they now are working on mitigating the case for us. So I'm just asking for a brief adjournment for this matter.
April 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case of the People versus Amanda Grove.
Andrew Childers, appearing on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Grove, who is present via Zoom. Ma'am, can you please unmute and state your name for the court?
Amanda Grove.
All right. What are we doing?
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have discussed this matter both with my client and with the people about the possibility of Ms. Grove participating in the restorative justice program. We're just asking for an adjournment so the people can talk to the complaining witness.
Probable cause conference, March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Ms. Grove, you're all set for today.
Court calls case
Thank
People
you.
versus Mario Hearn.
Assistant Public Defender Ashley Bishop on behalf of Mario Hearn reproaches.
Mario Hearn. Thank you.
We request a brief 2-week adjournment for further negotiations to reach a collective resolution. Thank you.
Probable cause conference, March 27th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Judge. Thank you. Bond continued. Court calls case People versus Brian Howell.
People.
Lord Yagi, Assistant Public Defender with and on behalf of Mr. Howell, who is approaching the podium. Oh, that's the third time. I'm sorry.
I know, we're counting now.
I'm not going to do it next time. Your Honor, this is going to be another adjournment request. I have been in touch with Oakland County Treatment Court. Mr. Howell is on board. The prosecutor's on board. We're on board. They have to complete a PSI eligibility interview. We don't have that scheduled yet. So, but I really think that would be the best option for Mr. Howell. So,
Right. And I think everybody's in agreement.
yeah,
Everybody else getting in line.
it's just getting in line. And
So how much time is it gonna take for this part to happen? At least we found a place, right?
And
That's progress.
It is. And I have email confirmation that they are going to proceed with him to the next step of the interview. The issue is they didn't give me a time frame. I specifically asked them yesterday via email, didn't hear back. Mr. Howell and I think probably it makes sense to do 3 weeks or around that time frame.
April 3rd, 2025, 9 a.m. We'll keep going. And
Thank you,
we'll
Your
make up
Honor.
their mind. All right, Hal, you take care. You're welcome. Court does call the case, People versus Tyrone James.
Your Honor.
Ready, Judge? Torshell Feature, Assistant Public Defender on behalf of Mr. Tyrone James. It looks like. What is? I got it. Okay.
Oh, hold it. How do you not hear me call the case? How do you? You're in the room. How do you? How do you?
Hey,
how do you not hear that? Feaster heard it and he's old. So how do you know?
I'm older than him. Stephanie Cannon on behalf of Mr.
So
we're setting it for a preliminary exam.
Then why do I have a green sheet?
Because Mr. Feaster is old.
Wow. Wow.
I'm so sorry.
Wow. No.
Yes, yes. So we're setting this for a preliminary exam, Your Honor. And yes, to my knowledge, all discovery is in.
Wow. Which people have their witnesses available the 25th?
We'll do our best, Your Honor.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before.
Judge Moore.
Is it more? Judge Moore.
One of these.
Bond continue. Thank you.
Thank you, Your Honor.
Clerk calls the case, People versus Quincy Jones.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones. Mr. Jones is approaching the podium. Your Honor, I have done a green slip for this matter.
How much time do we looking at?
Your Honor, this is, if the court remembers, this case last time we approached, I didn't, there hasn't been any authorization on that. Maybe if we adjourned it 2 weeks, we can track that. I don't want, he's here with his caseworker from Avalon. They have a lot of, to add double court dates would just be.
So the 27th will work.
Yes, Judge.
No, sorry. Without objection, March 27th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Calls case, People versus Brianna King.
Morning, Anna Mackey on behalf of Ms. Kingsley, who is appearing via Zoom.
Ms. Kingsley, can you state your name, please?
Brianna Kingsley.
Thank you.
At this time, we would like to adjourn this matter, please.
All right.
We request to adjourn.
Without objection, probable cause conference, April 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, Ms. Kingsley.
May I request that be by Zoom?
They'll have to submit the forms, so.
Thank you.
Thank you. Court calls the case, People versus Garrett. Is it Penagel?
After the line for the people.
Anna Mackey on behalf of Mr. Penagel, who is here in spirit, Your Honor.
Did not tell her to say that.
Yeah, but that may work. I'll grant you. In spirit, huh?
Your Honor, yes, he may be here in spirit, but I think he's drinking in reality.
Wow.
Ben has.
Who invited Lonnie to the?
Nobody. I'm
Nobody.
going to the warrant that's already outstanding.
Yes, there already is a community corrections warrant out. So we will leave the no bond warrant out. All right, thank you.
Thank you, Your Honor.
I guess that's kind of a spirit.
Have a nice day, Your Honor.
Pardon?
Have a nice day.
Is that it? Wonderful job you've done. And I didn't have to listen to Bellinger except one. All right, court calls the case, People versus India Robinson.
Assistant Public Defender, Kathy K. Ackerman, Your Honor, on behalf of Miss India Robinson, Your Honor, I do have a green sheet for the court.
Of course you do.
Ms. Robinson, state your name for the record, please.
Hello, India Robinson.
Judge, we're just asking for a brief adjournment. Ms. Robinson was just recently posted bond and we had not had an opportunity.
All right. Probable cause conference, March 27th, 2025, 9 a.m. Bond continued. All right. Thank you. No, 27. Court calls the case, People versus Emily Bates.
So there's a parent on behalf of the people.
Oh, she's back.
I'm back. Good afternoon. Assistant Public Defender Lauren Perny on behalf of Ms. Bates. Ms. Bates, state your name, please.
Hello, good morning. Emily Bates.
Thank you. All right, you're waiting that information.
Yes, we've been dealing, Ms. Bates has been dealing with her mental health provider. She's just trying to get us proof. I know we've been before, Your Honor, multiple times. It's just waiting on that documentation.
Got it. Okay. Probable cause conference, April 3rd, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thanks, Ms. Bates.
Thank you. Ms. Bates.
Thank you, Your Honor.
Court does recall the case, People versus Mark Capaldi.
That's the people.
Assistant Public Defender Asif Bashir on behalf of Mark Capaldi, who is here.
State your name.
Mark Capaldi.
This is a miracle. So let me.
More than a miracle.
So, all right, he's here. I had faith in you. I don't know what all these other people.
I had none. I lost all faith.
Well, no, you contacted the court. You told us you'd be running late. You're trying to get a jump. You got here. That's important.
Just came to see you.
Came to see me. All right. Thank you, sir. All right. Need an adjournment of this?
For putting my file to the side and.
Pardon?
Thank you for waiting for me to put the file to the side.
Not a problem. You think that young lady next to you, she's that got me to do that. So 4 weeks, you think, for the information?
Yes, yeah, thank you, Your Honor. 4 week
All right.
adjournment requested.
Probable cause conference, April 10th, 2025, 9 a.m. Bond will continue.
Thank you,
Thank you, sir.
All right, thank you. Court does call the case of People versus Maxwell Lawson.
Good morning, Your Honor. Maxwell Lawson.
Thank you. Okay, pick a PD.
First Assistant Public Defender Queen Anderson with Mr. Lawson. Mr. Lawson?
Yeah, it's an arraignment for an OWIS.
Did you talk to me?
I think.
So Ms. Yagi's case, Your Honor, she's coming.
I knew that long ago. No, I know you were trying to fill space and just hopefully he won't know that we're delaying. Go ahead, Ms. Yagi.
I apologize, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Lawson. I actually was trying to see if I could find Mr. Childers because I don't have an offer for Mr. Lawson. And we were trying to figure out what we were going to do today. At this point, rather than ask Your Honor to pass it, I think I'm just going to ask for a brief adjournment to try to continue conversations because I don't have an offer and that's where we're at.
March 27, 2025, 9 a.m. or as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Case People versus Julia, is it Sasinski?
They said they're gonna adjourn the payment.
Good afternoon, Your Honor. James Fatfelski appearing with on behalf of Ms. Sazinski. Can you state your name, please?
Julia Sazinski.
Your Honor, this is our first PC and there are some additional reports and videos I've asked the prosecutor's office to provide. So I'm asking for a 3-week adjournment if that's possible. Because sometimes
April 3rd, 2025, 9 a.m. or as your invite indicates, bond continues.
Thank you very much, Your Honor.
Thank you.
Enjoy the sunshine at some point today.
I don't go outside. Court calls the case People versus Frankie Leon.
Assistant Public Defender Jay Bellinger on behalf of Mr. Coaches. Please state your name for the record.
All right, I have before me a plea form. Indicates that the defendant would be pleading guilty to the charge of larceny, 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, that's the added count 3. Count 1 would be dismissed.
It should say 1 and 2, Your Honor. I'm sorry.
1 and 2 would be.
I apologize. I listed them, but if I
Yes.
one answer, I apologize.
Okay. Counts 1 and 2 would be dismissed. There is further the agreement and no delayed or deferred. Indicating defendant has made restitution in the form of a bond to the court for the full amount. Is that
Yes.
Yes, Your Honor.
my case? All right, real good. All right, that's the court's full understanding of the agreement.
Ours as well, Your Honor.
All right, very good. May I have this one?
Raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Frankie Leon Jr.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is a subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
Yes?
Yes, sir.
All right. And understanding all of that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Sir.
Any question regarding any of those rights? Okay, who's raising their hand?
It's my. I'm sorry. I just wanted to clarify something.
Well, hold on. Does anybody know what she's trying to clarify to the court?
Your Honor, I will be addressing bond after this. I will be asking to address bond after this, Your Honor, after the plea, but for purposes of the plea, I don't believe there are any questions pertaining to the plea itself.
Okay.
I'm here, Job.
Who are you? Okay, it's everybody talking to me. All right, so as to both sides, despite the hand being raised, you think that I can proceed with the play?
I do, Your Honor.
I don't see any issues moving forward.
All right. All right, sir, you understand the maximum penalties, correct?
Yes, sir.
All right, and you signed an advice of rights form, correct?
Yes, sir.
Do you have any questions regarding any of those rights?
Yes, sir.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to sleep?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
October 8th, 2023, at the location of 771 Airport Boulevard, Pittsfield Township, Washington County, State of Michigan. What'd you do in relation to First Merchants Bank that makes you think that you're guilty?
Say it again.
What did you do in relation to First Merchants Bank that makes you think that you're guilty?
Sign my name on the check.
I'm sorry?
Signed the check.
Okay. You're gonna have to give me a little bit more detail than that.
Your Honor, if I may.
Yes.
Was there a valid account that you signed the check on?
The person told me it was, but I'm assuming it wasn't.
Did you and you came to find out that there was no active account on that?
Correct.
Did you write another check on that account? Was there more than one check that was written?
It was just them two.
Okay, so there were two.
I believe so. Yeah.
Yes.
Yes.
Okay.
Well, we need a little bit more than that. So
I understand.
then you went.
Yes.
So after the first check, you knew there was not a valid account. Is that right?
No.
You didn't?
No, I didn't. I didn't really know. Didn't know really much about bank accounts at the time. Or none of that.
So let me ask you this. The 2 times that you went in.
I only went in once.
Okay, you only went to the bank 1 time?
I ain't going to the bank at all.
This.
At the Costco, Your Honor.
It's Costco, I mean.
Okay. The check at Costco, that was, no, it didn't have the account.
7, yes.
2 checks.
So you went to Costco.
Yes, sir.
You wrote a check. You did that twice, is that right?
Yes, sir.
Yes?
Yes, sir.
The second time that you went in and wrote the check at Costco. Pardon?
Would have had to have known the time that he's going to take the plea today.
Okay.
Sorry, Your Honor.
The second time that you went in, did you know that the check would not be a valid check?
Yes.
Pardon?
Yes.
Okay. And so in doing that, you attempted to get goods from Costco's that you hadn't paid for because you knew the check was no good. Is that correct?
Correct.
Correct? Okay. Was the total amount of the goods that you received, was that in excess of $200?
Yes.
Yes? All right. Yeah, right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
We are satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation is ordered at 14A1 probation. Sentencing in this matter will be April 9th, 2025, 9 a.m. That is before me. As to bond.
As to bond, Your Honor, Mr. Linyoon's wife is in the court today. The family is prepared to move to North Carolina where he has some jobs lined up. He did give me an address where he would be staying. He is asking for permission to move to that state as early as today. I did talk to him about the distinct possibility of you saying yes and no. I talked to him about him meeting with probation, setting up a PSI. I talked to him about the potential of being able to do the plea via Zoom if the court so allow. He does financially support his entire family. His wife has made it known to me that she cannot do this move without him. He is asking again for the court's permission to move to the state of North Carolina. I did talk to Ms. Londy about this. She said she'd leave it up to the discretion of the court, but she had otherwise no issue with it.
Is that correct, Ms. Lonnie?
Yes, Your Honor, of course.
So what I'll do is this. After the defendant has his pre-sentence interview, I will give the defendant permission to move to North Carolina.
Thank you.
In all other aspects, bond will continue.
Thank you.
Court calls case People versus Craig Manor.
Lori Yagi, Assistant Public Defender, with on behalf of Mr. Manor, who is approaching and standing to my right.
Craig Manor. I have before me a plea form that indicates guilty to 2 charges. Added count 3 of use of a controlled substance, a 1-year offense. Added count 4 of operating while visibly impaired, a 93-day offense. Upon his successful plea to counts 3 and 4, counts 1 and 2 would be dismissed. That
is correct.
That's the court's full understanding of the agreement.
Yes, Your Honor.
All right. May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Craig Manor Jr. Has he signed an advice rights form?
I
believe so.
I believe so, but I can have him sign another one, Your Honor. I apologize. I had thought he did it previously. Thank you. I apologize. You have, okay. Will you just sign it again? Thank you.
Sorry about that.
Sorry, Your Honor.
Third is this court's understanding you're going to be pleading guilty to 2 charges. Is that your understanding? Yes, sir. All right. First of all, the court's understanding you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that? Yes, sir. It's also this court's understanding that you're going to be pleading guilty to an added count 4 of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail. Court could order 93 days in jail up to a $300 fine plus court costs. The court could order any rehabilitative services or community service the court deems necessary. The court could order your vehicle forfeited. Could order your vehicle immobilized. Court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. I also have to advise you, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. Do you understand that?
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you are indeed guilty of this offense, of these offenses? February 13, 2024, at the location of westbound I-94 near State Street, City of Ann Arbor, Washtenaw County, State of Michigan. Were you in possession of a mixture containing fentanyl?
Yes, sir.
Did you know that you were in possession of that?
Yes, I did.
And had you used it?
Yes, sir.
All right. On that same date, at that location, were you operating a motor vehicle?
Yes, sir.
Prior to that operating that motor vehicle, had you consumed alcohol and ingested the controlled substance?
Yes, sir.
All right. Were you stopped by the police or was there an accident?
I was pulled over already. I had a flat tire.
Okay, so you were on the side of the road, the police arrived?
Yes, sir.
All right. Were you ultimately arrested?
I went to the hospital that night.
Okay, you went to the hospital and there was a blood draw?
Yes.
All right. And what were the results of that blood draw?
That was positive for alcohol and opiates, fentanyl.
Okay, it was so the fentanyl did show up in your blood test results?
Yes, sir.
Or its derivatives. And what was the blood alcohol content?
0.102.
Thank you. Sir, do you have any reason to dispute those results?
No, sir.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and your ingestion of the fentanyl?
Yes, sir.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
April 1st at 9 a.m. with Judge Valvo.
April 1st, 2025, 9 a.m. before Judge Valvo. Bond with its conditions will continue. Thank you. Court calls case of People versus Charles Meade.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Charles Meade. Mr. Meade, please state your name for the record.
Charles Meade.
Our apologies, Judge, about Mr. Meade being on Zoom. Apparently, he thought he had permission, and I don't know that he did. So in the future, I'll try to make sure that's clarified.
All right.
My understanding is that Mr. Meade is currently found incompetent.
Yeah.
In a treatment facility, I believe in home. I spoke to Mr. Childers about this a little earlier today. I think what the problem is, we have to find a way for him to get the forensic center treatment to be restored. And I need to find a way to accomplish that without him losing his bed at his current treatment facility, if at all possible. What I'm requesting is adjournment. I try to work with our social work division and facilities and try to figure out how to accomplish that. If I misstated something, Mr. Childers, please.
No, I agree with that, Your Honor. From my reading of the reports from the Center for Forensic Psychiatry, it appears that he's never been present for them to start any of the treatment in his restoration. And And yes, it appears that there may have been, was there a bench warrant at some point in this file? My notes are a little unclear.
I think there was, this is my first time handling this file, but I believe there was, according to our.
At some point.
Okay.
Yes.
Um,
All right. How much time do you think you need?
I gotta make a bunch of phone calls back and forth. I'd ask for about 3 weeks, Judge, to try to get something set up and make sure, hopefully then I can confirm to the court he's
and
there.
I guess I would also put on the record, obviously, Mr. Fisher, it wouldn't surprise me if the Center for Forensic Psychiatry is in order at some point.
Okay.
Because of how much asked. So
Do we have this?
prepare that and present it to the court.
Thank you.
You see, that's right. Okay. So I will adjourn that to April 10th,
Thank you, Judge.
2025, 9 a.m. or as you're invited. Bond with its conditions will continue.
Thank you.
Thank you. Court does call the case of the people versus Davon Moore.
I'm Laura Yagi, Assistant Public Defender with and on behalf of Mr. Moore, who's standing to my right.
Your name, sir? Thank you. All right, what are we doing?
So, Your Honor, I believe we're requesting a preliminary examination date in this matter. I do believe discovery is complete. We have the body worn, the video, several reports. I would ask if the court would consider setting it out to a further exam date than the 2 weeks. If the court would consider it.
Why?
He does have another pending matter in Wayne County, and there's a little bit of research and communication I want to do with that attorney before the exam in this case.
All right. Any objection to that from the people? Would the people have their witnesses available April 8th?
We'll do our best.
Yes. So what I will do is preliminary examination in person, April 8th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case, people versus Derek Penaredes.
People.
Probably said that all wrong. Probably flows smoother than that.
Ready, Judge. Joe Feaster, Assistant Public Defender. Please state your name for the record, sir.
Derek Penaritas.
Thank you, Judge. There should be a green sheet in the file.
There is.
Thank you. This is our first PCC in this case. We have not had a chance to sit down and review the discovery. If we have a couple weeks of adjournment, please, we'll sit down and do that, Your Honor.
Probable cause conference will be adjourned March 27th, 2025 at 9. Yes, that's the bond.
Thank you. I can't tell from JIS what his bond conditions are. And if it's on a square or a sober link.
He does have a sober link, Your Honor.
He has a sober link.
I would request that the court consider the entry of a scram tether. This is an OWI 3rd, as the court can see, and the allegations include that the defendant had a blood alcohol content above 0.26, and his most recent prior, I believe, is from 2022 for OWI. Yes, 0.267 is the blood alcohol.
0.267.
Yes.
Thank you, Judge. I did just have a brief conversation with my client about the sober link. I explained to him about his requirements of that and having to blow on time every time as required. He indicates that he's had it for the last 2 weeks, that he has done everything appropriately, and that he will continue to do it appropriately. He would like to stay on that. I told him that if he fails, the ramifications are incarceration.
How many times a day are you blowing?
2 times.
Yeah, see, that's part of your problem.
More?
So What I will do is I won't switch him to a scram, but he will blow 3 times a day. We're gonna need new order.
Yes, Your Honor.
All right,
Thank you, Your Honor.
all right.
Thank you, Judge.
So bond will continue with that condition.
Does community corrections notify him of those 3 times or do I?
I'm signing the order.
Okay.
So
Thank
we'll
you.
get there. All right.
Wait a
Thank
minute,
you.
hold on.
You may want to stop over at community corrections, tell them that you've been increased to 3 times per day. And they'll give you the instructions as to what the timing of those blows are.
That's my question. Thank you, Judge.
I answered your question?
You did.
I'm reading your mind.
Thank you.
There's some bad things in there. Court calls case People versus Thomas Riveros.
Eshalani for the people.
Rivera, excuse me.
Stephanie Can on behalf of Mr. Rivera, who is standing to my right. Mr. Rivera, when you are ready, could you state your name for the court?
Tomas Rivera.
Okay, he's waiving his right to preliminary examination.
That is correct, Your Honor.
Is that what you're doing, sir?
Yes.
All right, you understand a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we would waive formal reading and my client would send you.
Defendant never waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
May 5th at 1:30 PM with Judge.
May 5th.
Yes, sir.
May 5th, 2025, 1:30, Judge Hamud.
Thank you,
Bond
Your Honor.
with its conditions will continue. Thank you. Court calls case of the people versus Arisha, is it Rodriguez? Probably get that.
Good afternoon, Assistant Public Defender on behalf of Ms. Rodriguez. Ms. Rodriguez, please state your name for the record.
Arcia Rodriguez.
All right. I have before me a plea form that indicates that the defendant would be pleading to 2 charges, the stated count 3 of domestic violence, a 93-day offense, as well as an added count 4 of attempted resisting and obstructing a police officer, a 1-year offense. Upon her successful guilty pleas to those charges, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
Correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Arcia Rodriguez.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding? Yes. All right. First is the charge of domestic violence, the count 3. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. The other is an added count 4 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of domestic violence, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing the police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a comprehensive podium. Those are your rights. If you are part of a trial, you understand by pleading guilty, you'll be giving up those rights as well as all the rights of that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of these offenses?
Yes.
February 11th, 2025, at the location of 2671 International Drive, Ypsilanti Township, Washington County, State of Michigan. What did you do on that date involving Angel Rodriguez that makes you think that you're guilty?
What was it?
What should you involving Angel that makes her?
Oh, Angel, I grabbed him by his shirt and ripped his neckline.
Okay. You did that on purpose?
Yeah.
Okay. And you didn't have his permission to do any of that?
No,
Okay. And who is Angel to you?
my husband.
Okay. And ultimately, did police arrive?
Yeah.
Okay. And what happened regarding your interaction with the police that makes you think that you're guilty of offense of attempted resisting and obstruction?
Oh, I disobeyed them when they asked me to put my hand behind my back. I like yanked away and
You made it difficult or obstructed
Yeah.
because they were arrested.
Yeah.
correct? And you did certain actions in terms of yanking away or not following their commands, in
Yeah.
essence, to try to obstruct their ability to arrest.
Yeah.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
If people are satisfied, Your Honor.
Satisfied, Judge.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 14B. Sentencing in this matter will be
April 17th at 10 a.m. Judge Washington.
April 17th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Anything, Esteban?
Yes, Your Honor, we did submit a stipulation and proposed order to change the no-go to, as the victim in this case has since moved. She's also wearing a tether, so we're asking the court to lift the no-go to provision and allow her to remove the tether. And then I have one other request that's not included in the stipulation when the court is ready.
I signed the stipulation. All right.
The last request is regarding the children. There's also a no contact bond condition that she cannot contact the children. I believe one of the children was present at the scene. There was a CPS case. It's since been closed. The children are being cared for by her mother. She just wants to see her children and get them back into their normal routine and back to school.
And Your Honor, I'll leave it in the discretion before we did get confirmation that the victim is no longer in the country. So.
Okay. So why don't I have three, it looks like 3 children?
Yeah.
Okay. So counsel, why don't you, I will lift that. If you'll just submit an order to me, I'll lift the no contact regarding the 3 children.
Okay, I will do that today.
All right, thank you. You get that over to us, I'll sign off on that before it goes over to 14B. Okay?
Thank you.
Thank you. You're welcome. Court calls the case of the people versus Jermaine Shaw.
Yagi, Assistant Public Defender, written on behalf of Mr. Shaw, who's approaching counsel, the podium and now standing to my right.
Your name?
Jermaine Shaw.
Thank you. What are we doing?
Your Honor, I apologize. I have a green sheet. I'm requesting to adjourn the comp hearing. My colleague received information and a report today as to updates as to Mr. Shaw's treatment. He does also have a case in circuit court that I located a report that's pretty extensive, and I wanted a chance to review it before sharing it with the APA and figuring out basically a plan moving forward. But we are pleased to report that Mr. Shaw is doing well in his current treatment.
Okay. Order night adjourn at April 10th, 2025, 9 a.m. Where's your invited? All right.
Thank you, Your Honor.
Thank you. Court calls case people versus Christopher
People.
Quinn Anderson, with it on behalf of Mr. Shed, who's approaching. State your name for the record, Mr. Shed.
All right. I have before me a plea form that indicates that the defendant would be pleading no contest to the charge of disturbing the peace, the 90-day offense. Upon a successful plea to that charge, count one would be dismissed. There is further the agreement and no delayed or deferred.
That's correct, Your Honor. It'll be a no contest plea due to potential for civil liability and lack of sufficient memory. We'd ask Your Honor to find the elements of the higher offense and accepting the plea to the lesser.
Thank you. All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Christopher Shedd.
All right, sir, it is his court to understand you're going to plead no contest to the charge of disturbing the peace. That's a misdemeanor punishable by up to 90 days in jail and or a $100 fine or $500 fine plus court costs. You understand that, sir?
Yes.
All right. Do you understand what a no contest plea is?
Yes. I watch you on a regular basis.
Pardon?
I watch you on a regular basis.
Oh, that's nice. Okay. Let me explain it to you so that you can acknowledge it. Okay. Thank you. A no contest, two things about a no contest plea I need you to understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Oh, yes.
Okay. Now, understanding all of that, do you still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5, the rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
Now, if you watch me, what's my next question? See, you didn't know. Yeah, all right. So, you understand you're giving up your right to appeal of rights, sir?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 24-60178. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report and looking to the higher offense, court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor. Thank you.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
April 1st at 9 a.m. for Judge Valvo.
April 1st, 2025, 9 a.m. before Judge Valvo. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the people versus Robert Schellberg.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender here on behalf of Robert Schellberg. As of today, I have not been able to successfully contact Mr. Schellberg. I submitted a green sheet on his behalf, and I request brief adjournment so that we can get in touch.
All right. He's also not reported to community correction, and there's a bond violation appearing on that one. Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $25,000. Cash surety. That warrant will issue immediately. Court calls case people versus Romeo Serba.
Andrew Childers appearing on behalf of the people.
On behalf of Mr. Serba, who is on Zoom.
Serba, can you state your name, please?
Romeo Serba.
Thank you. All right, what are we doing?
Your Honor, we're asking for a brief adjournment. We are wanting to refer our client to the AIM division and work on a mitigation letter to provide.
All right, do I have a green sheet?
We already submitted that.
Oh, you're pulling the Kalina Anderson game?
Yes.
Okay. We'll find it eventually. Probable cause conference will be adjourned to April 3rd, 2025. 9 a.m. Bond will continue.
Your Honor.
Thank you.
Thank you.
Thank you, sir. Court does call the case of the people versus Eric Smith.
As in on behalf of.
Assistant Public Defender Natalie Pate with an on behalf of Mr. Smith, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Eric Smith.
Okay. And you're looking to make sure you can meet with.
Yes, Your Honor. The people have made an offer in this case and that they generously said that they would keep open to an adjourned PCC date so that I could have an in-person meeting with my client, which we have scheduled for tomorrow. So I would respectfully request an adjournment for that purpose.
Probable cause conference, March 27th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you, Mr.
Court calls the case, people versus Gabriel Stephen.
Public Defender Natalie Pate with an on behalf of Mr. Stephen, who is also present via Zoom. Sir, can you please unmute and state your name for the court?
Hi, yes, my name is Gabriel Alexander Stephen.
All right, I have before me a plea form that indicates the defendant will be pleading no contest to the charge of larceny 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
The plea would be under a prosecutor's deferred, Your Honor, but other than that, that is the complete agreement I've discussed.
Yeah, oh, I see, it's up there. Got it. Under a prosecutor's deferred. All right.
That is correct, Your Honor, and that is, and my client will be pleading no contest today. Added count 2. Thank you, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name for the record.
Gabriel Alexander Stephen.
Okay, you can put your hand down. Sir, it is this court's understanding you're going to be pleading no contest to the charge of larceny, $200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, I understand.
Do you understand what a no contest plea is?
Yes, I understand.
All right. First thing you need, there's 2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
That's correct.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead?
No contempt.
No contempt?
Or do you mean no contest, Mr. Stephen?
No contest. I'm sorry. I'm sorry.
All right. You understand that by pleading no contest, you will not have a trial of any kind.
That is correct. Yes, I understand.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You understand you're giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, I understand.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
The court has been provided Pittsfield Township Department of Public Safety report for their case number 23-18-505. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be April 9th.
Yes, sir.
April 9th, 2025, 9 a.m. That's before me. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Thank you,
Thank you.
Mr. Stephen. I'll follow up with you. All right. Thank you.
Thank you.
Court calls case People versus Derek Stewart.
Question on the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Stewart. Mr. Stewart was here this morning, but he left when I advised him that his hearing was in this 12:30 block and he's not here. He is scheduled for a forensic, so this is a competency hearing. He is scheduled for the hearing interview on Monday. And I did advise him of that. It's at our office. I asked for an adjournment for the record. I do know he was here. I did speak with him.
And he has been here lately, Your Honor. It looks like his last failure to appear was in last fall. We have had issues with him not going to the CFP, so maybe we could go and just see if he keeps his appointment. We could go like 1 or 2 weeks to see if he keeps it.
All right. What I'll do, adjourn this hearing to the 27th. March 27th, 2025, 9 a.m. And on your representation, Ms. Perry, I'll adjourn it as opposed to issue a warrant.
Thank you.
It doesn't mean I believe you. I'm just doing it based on
But an officer of the court.
You know, I get it. I'm just saying. All right, court calls the case. People versus Colin Vandermeer.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vandermeer, who appears via Zoom. Mr. Vandermeer, will you state your name for the record?
Colin Alexander Vandermeer.
Thank you.
Your Honor, we are still awaiting treatment at the Forensic Center on this. So I have some
conversation earlier today, that one I did about maybe another way to get this done. We're happy to discuss it with the bench if the court wants a little bit more information. But hopeful we might be able to get this done
Get it done.
in
Okay.
a slightly different way.
All right. How much time would you?
I have to confirm if we're able to do what Ms. Lonnie and I are discussing with with my management. So maybe a few weeks just as a status check.
What did I do? April 10th,
Thank you.
2025, 9 a.m. Bond continue.
Thank you.
Yeah. Let's call the case, the People versus Lewis for all day.
Andrew Childers appearing on behalf.
Assistant Public Defender Ashley Bashir here with and on behalf of Louis Baraldi. Mr. Baraldi.
Louis Baraldi.
Thank you. What are we doing?
We are requesting an adjournment. We're requesting a 4-week adjournment. Our AIM division is producing a report for consideration by the people and also.
April 3rd, 2025, without objection, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus Vershawn Vincent.
Defender Hannah Apple appearing on behalf of Mr. Vincent, who may be appearing via Zoom. Had limited.
No.
Mr. Vincent typically appears via Zoom. We're still in negotiations regarding a resolution. I did speak to him via text earlier this week and then this morning.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue.